conflict just like this one happened about 3 or 4 years ago. Okay, so this is a New South Wales question, right? So the first thing that you should think about is, right, well, there's nothing about appeals on question of law. There's nothing about that there, so that's not an option. There was nothing about an appeal on question of law for the previous question either. So that could be an option. Sometimes lots of legislation does allow for appeals on questions of law, but in neither of our questions for last year's exam. So no appeal on question of law, no ADJR Act in New South Wales. That means you have to go to the New South Wales Supreme Court and in what's called the inherent jurisdiction. So every year there's some poor student starts doing this big discussion of the ADJR Act. Is it a decision of an administrative character made under an enactment for New South Wales question? And one, it's just wrong, because there's no ADJR Act here. And two, it means it's a big distraction from dealing with the real issues in the problem question. So just, make sure you don't make the mistake. All right, so there's this coal mining provisions, and this one is actually divided into 3, and they're just different people that we're revising, and different issues come up. So it's here. So the first people we have to advise is this company who have been told that their application to expand their coal mine has been unsuccessful, and we have to advise them on whether we can challenge the decision in court and the grounds of review that we can argue. So there's a few grounds of review there. Anyone want to raise one? Yep.
Like prejudgment and inflexible application of policy for the
Okay. Because of
deciding
this my only option is to
Yeah.
Okay, so inflexible application. Yep. So yeah. The inflexible application of policy, and the kind of sign that that's happened is they're referring to this policy that's of the Minister for Regional Development, and they're saying that because of this policy, the only option then is to refuse. So that's a sign that they just have automatically done this, and it's problem with inflexible application policy is that the Act is giving them this discretionary judgment, and they're not exercising discretion and thinking through all the issues. Only option now is to do this. So that you can put it under the heading of inflexible application. And what case would you rely on for that, by the way? Rendell. Okay, that's fine. There's another way you can kind of make the same argument, and it's also relying on Rendell. And that's acting under dictation of the Minister for Regional Development, right? So it's this department official has just been told what to do by some minister, and that's a problem. Okay, so there's an added complication to this. There's an added complication, and does anyone see it or wants to raise it? Okay, there's an added complication, and it relates to another ground of review that's arguable. And so this departmental official who's made the decision is acting as an agent of the minister. See, so it's the Minister for Coal Mining who can grant or refuse the expansion application. And it's the departmental official who's actually made the decision, right? So there's nothing in the legislation about delegating authority to the departmental official. So that doesn't count. So the only way that the official who made the decision, the only way that it can be okay is if the official was acting as an authorised agent. So is he acting as an authorised agent? How do we work that out? Well, there's case law that says when a minister is given authority by legislation to make decisions, departmental officials are allowed to make the decision. And the case for that is called Carltona. It's a kind of the landmark case for these authorised agents. And the court, I think it was the Court of Appeal for England in the 1940s said, well, ministers have lots to do. They have their own, they will have cabinet responsibilities, they'll have to deal with residents in the area that they're representing. They can't be expected to make all the decisions that they've been given power to make. So the Carltona case looks like it's directly authorising that. We have a case that says, well, maybe the Carltona case doesn't directly authorise in every single case. And the case is called the Nelson Bay claim, something about New South Wales Aboriginal Land Council is the formal title, but it's called the Nelson Bay claim. Nelson Bay is an area just north of Sydney. And in that case, the Court of Appeal said, well, if the decision-making power is about big picture policy issues and about issues that there can be disputes between government departments, then maybe that kind of power can't be given to some departmental official to deal with. So that wouldn't be the case here. This is not big picture policy, I don't think. It's fairly focused. They just have to consider the detriment to other people, to other residents. That's the main consideration. Now, I started all that discussion by saying there's a bit of a wrinkle in the, a bit of a complication with the earlier argument about acting under dictation. And the complication is that if it was the Minister for Coal Mining who was telling the department official what to do, that would be okay if he's acting as the agent, right? But here it's not the Minister for Coal Mine who's telling the departmental official what to do. It's a different minister telling the person what to do. So there's that slight complication in there. Good students would, like a really good answer to this problem question, would pick that up and say, well, it makes a difference in the end. It probably makes that all argue. Okay, so what else? What other issues are there? Okay, so where are we? So the Act says the Minister for Coal Mining, now the department official, must consider the detriment on adjacent properties of the expansion. And so the reasons say, I've considered submissions by neighbours from the horse breeders about the impacts and the detriment. But then we come down here and said the Australian Coal, the applicant, has also submitted this additional submission after it made the expansion application. So it looks like this hasn't been considered because there's no reference to it in the reasons. There's only reference to other people's submissions. Is that a problem? Or why would it be a problem? So we have to go back to case law that we did in March. That's asking a lot to answer this. And it's kind of important, but kind of in the details of the case. Okay, so the case is Pecco Wallsend, and it was also about mining, and it was also about detriment, whether detriment had to be considered. And in Pecco Wallsend, the mining company deliberately held back on supplying information until the initial decision-making process had, the initial step in the decision-making process had finished. But Justice Mason in Pekka Wallsend said, well, it still had to be considered, and he said that that's because decision makers have to consider the most recent, up-to-date and accurate information available. They hadn't. In Pekka Wallsend they hadn't because they'd missed this submission, and you can use the same argument here, but to know that that's an issue, you have to have a pretty good understanding of the Pekka Wallsend case, because the issue is similar. All right, so that's a possible argument, and there's one other possible argument. Yeah, so in the reasons down here, so the departmental official has just completely relied on what the Minister for Regional Development said, and that the worry there is about prospects for employment and the New South Wales economy. So is it possible to argue that prospects for employment and the New South Wales economy are not relevant under this Act? It might be a hard argument, but it still might be possible because this section of the Act just gives one consideration, one expressed consideration, the detriment on adjacent properties. Not big picture about the economy. What was the other one? And not questions about employment, whether this one's going to have an impact on the neighbours. So the argument would be that's deliberate. It's deliberate to focus the decision maker's attention on this specific issue. All the other stuff is outside of the parameters of the minister's decision. That's a possible argument, right? So they would probably come back and say, well, coal mining does have this significance, but it's still worth putting in. Okay, so that's the first question. Second one is, soon after that application was refused, the government has amended the coal mining regulations and amended them to say any expansion to coal mining operations in this district is prohibited. Okay, so we've already seen before that the government has this idea of prohibiting coal mining in the area, and that it's actually implemented now through this regulation. So they get through all this, and then it says, in particular, they're concerned that it's unfair that the government has amended the regulation without giving them an opportunity to be heard, right? So that's prompting you, can this company argue that there's been a breach of procedural fairness? Okay, so according to the implication principle, the procedural fairness is required for decisions that affect people personally, directly, but not for decisions that affect the public generally. And Justice Mason said of that is that there will be lots of people indirectly affected. So what's going on here? And the one other bit about that is that the classic example of decisions that affect the public generally, the administrative decisions that affect the public generally are regulations. Laws apply to everybody, and so usually recognise that procedural fairness, well, it's just kind of assumed and accepted that procedural fairness is not required for regulations. Would that be the case here? Yes? Kieran West. That's Kieran West that says those. That says the principle. So what I was saying then is pretty much paraphrasing Kieran West. Right? So that's the principle, and so then you need to apply this principle now. So with this idea that Justice Mason had of decisions that affect the public generally mean that procedural fairness is excluded, would it apply to a reg that applies only in this district and only to 2 companies? Right, would that be an exception to that? Would it be an exception? Yes? Arguable for an exception. You'd be kind of breaking new ground maybe, because regulations aren't usually thought that procedural fairness is required. But there is a case in England where regulation was made that just affected one company. And the UK Supreme Court said, yeah, it's a reg, usually we wouldn't require procedural fairness. But when it affects one person, then that's different. So the same kind of argument would be made there. Right? That would be a good argument, because most admin lawyers would just think, no, it's a regulation, of course you can't. What else? Can we have any other arguments to make that can help Mr. Plains Cole?
The regulations going beyond the scope
Yeah.
of the Parent Act.
Why?
It's prohibiting something when it was just meant to be doing things that were necessary or convenient.
Yeah, so prohibiting, right, is prohibited. Are there any exceptions to that? Or do you know the case? Can you remember the case?
Oh, like the one about the egg marketing? Oh, no, the council.
The council and the houses and things. So the case is called Swan Hill and Bradbury. And so Swan Hill and Bradbury, right? And so, yeah, there's some complications about, should make sure you're familiar with that case. It's important and quite subtle reasoning about what prohibition means. And it kind of means more than what you think it does. Justice Dixon is a kind of genius at making things more complicated than what they seem. But one thing he said is that it might be possible for a reg to prohibit things when the Act doesn't expressly say it. It might be possible, and he's basically saying there could be implied authorisation to prohibit things. Do you remember what he said about that? Anyone? Yeah.
If the subject matter is something very nasty,
Yeah.
very evil.
Evil, yeah. If something's evil in itself, right? So maybe that would be permitted if what's being regulated is an evil in itself. So, is coal mining an evil in itself? So, you have to kind of work through that. All right. Okay, so they're the issues for question 2. And then we get on to the third one. And so the horse breeders in this district have joined together, put themselves into an association, and they conduct protests at the entrances of these coal mines, preventing access to the site. And so the government, wants to protect the coal mines and protect the workings of them. And they do it by making these provisions that are designed to regulate and restrict the protesters from stopping access to these mines. So they want advice as to whether they can challenge Clause 12 and the administrative law grounds, not the constitutional law grounds. Some of the teachers were worried that students would go off into the constitutional issues. Are you guys doing fair comment, one? Yep. So it does raise constitutional issues in practice, but we've also done this issue in administrative law, and the question prompts us to think about the case law that we've done on that. But so for this one, I might just go back that for each of these parties, there are potential issues about standing. Potentially, right? At a very kind of general level. So this Australian Coal Limited, the first people that we're advising, go back to them. There's no worry about standing for them. They'll have standing. They're the ones who had their application refused. no one would think that there's an issue about standing there. The government definitely wouldn't raise it as an issue. That hasn't happened with the second company because there's no application that's been refused. They just want to challenge the regulation. So there's a potential issue there, but it's not a hard standing issue. It's an easy standing issue. Why is it an easy standing issue?
It's an interest-based issue for them.
Someone want to relay that?
I was saying it's easy because it's interest-based.
Interest, yeah, so they have an interest, right? What's the interest? So we have to show a special interest, and they have, this company has a special interest. The kind of interest they have is one that we've seen in numerous cases. And the judges just say it's a commercial interest. In the Bateman's Bay Aboriginal Council case, where it was about an insurance scheme, and in a case called Argos, where they were supermarket owners and there were going to be new supermarkets coming into their region and increasing competition. Judges in those cases said, well, they have a commercial interest. Of course, they have standing. Okay, so no difficulty with standing for the first two. Is it the same for these protesting group? They could, because they're breeding these horses, right? So that's what they do in this region. They breed horses and sell them, and they race them all around the world. Okay, in the Hunter Valley they do it, but also it's kind of clear that that's why there's a dispute, because these horse breeding companies are like the best in Australia, and it's a money-making industry. So the horse breeders probably have a commercial interest, but the association is this protesting group, and this does engage some case law. In the Australian Conservation Foundation case, Justice Gibbs said, well, if the members of an association have standing, well, they should just bring the proceedings. An association won't just be given standing just because its members have standing. So the worry in this is that the individual breeders may have standing to challenge this, who want to do the protest, but not the association. And that's because of a clear point that's made in Justice Gibbs's judgment in the Australian Conservation Foundation case. Okay, so there's some complications in that, but probably you can get through them and bring the case. So we have to advise them on the administrative law issues as to why they can challenge this regulation. Okay, so this also is going back quite a way in the course, into the first few weeks. So remember, we did a case about protesters. Remember the protesters case?
Is it Evans?
Evans, New South Wales. What was the protest?
World Youth Day.
World Youth Day was a huge Catholic event, and that kind of took over the city. They had events in Hyde Park, at Randwick Racecourse, and these big processions between the places they were having their events. And there were protesters who wanted to protest about Catholic Church kind of principles. And so some aspects of the regulation in the Evans and New South Wales case was invalidated, and some part was supported, or it was said to be okay by the federal court. So the wording in this is similar to also about protesters and protecting a particular interest group, here it's the coal mines. Anyone remember from Evans in New South Wales how what was decided, what was invalidated, and what was said to be okay?
They severed the part about the annoyance.
Annoyance. What was wrong? So in the legislation, the protesters were not allowed to annoy the World Youth Day participants. What was wrong with annoyance? The word annoyance was used in the regulation. That was determined to be invalid. What was the legal problem with annoyance?
The reaction variance.
Reaction would vary. Exactly. So the people in the World Youth Day event, some of them would get annoyed really easily. Like all humans are different in how they get annoyed. Some might never get annoyed, or take a lot before they get annoyed, and others get annoyed really easily, right? So the judges were saying it's not fair to the protesters for them to not really ever know whether what they're doing is going to have the harm that the law is designed to stop. So how would that adapt over to here?
Yeah. There was no objective criteria.
There's no objective criterion here. Yeah. Provoking is the particularly bad one, right? Because you would never know. It's the same issue, right? You'd never know. And so in Evans and New South Wales, the two words were inconvenience and annoyance. And the judges said annoyance is no good because that's too subjective, you'd never really know that. But inconvenience, they said, that's not so bad. And especially it's not so bad if you read down the word inconvenience to mean obstruction. So the inconvenience that the protesters were not allowed to do was to put up barriers and things to obstruct the World Youth Day participants from having their march. Okay, so if that's right, Evans New South Wales is right, if we take that as our model, then provoking is probably out. The protesters are allowed to do provocative action, but they're not allowed to obstruct. And that kind of makes sense, right? Because that makes sense within the scheme of the Act, because the Act is about regulating and enabling coal mines. So workers have to be able to get in there, but really, whether you're annoying workers or not, what has that got to do with being able to get into work or out? And especially the reasoning is that, it's unfair for the protesters to have their political communication entitlements restricted on this really uncertain basis. That's the point in Evans and New South Wales. All right? That all makes sense? Any other grounds we can argue for false, not coal? Yep.
Well, same as the other one, it's prohibiting and making an offence when the parent.
Oh, okay. Okay, right. So it's an offence. Yeah, okay. So yeah, it is. I hadn't thought of that one, but yep, you could do that. You can argue that point. There's another way to argue that point. So we have in our case law on regulations this concept of proportionality. So you guys will have done proportionality in FedCon now, right? Gone through all the steps. So admin law doesn't have all the steps. It's just is this too blunt a law for dealing with the purposes of the Act? And so proportionality, it's been accepted for decades, since the 1930s, that proportionality can be used for review of regulations. In other aspects of admin law, review of administrative decisions, it has to be tied into unreasonableness, but for regulations, it's just can operate on its own. And the way they refer to it is a question of whether the regulations are reasonable means for achieving the purposes of the Act. A reasonable means for achieving the purposes of the Act. Are these regulations reasonable means for achieving the purposes of the Act? That's the issue. Well, they're pretty blunt. The reason protesters often modern protesting involves recording the protest, so you can put it on the internet and have TV stations come and broadcast it. It's in the election. Remember last week people hung themselves off the Harbour Bridge. They did that because they knew television cameras would come and film them, and the whole protest worked because they knew that they would be filmed. So modern protests require this, and so to prohibit all that seems pretty broad. For really, the purpose of the Act is coal mining and enabling it to happen. Obstructing access, sure, that's understandable. But do they have to go this far into limiting political communication? Plus is an offence, plus fine $10,000 and maximum 4 years? Well, then that's super blunt now. So it is possible to argue, I think, that this is disproportionate to the purposes of the Act, and the way you'd argue it is through the case called, it's called, the reason I have to look it up is because it has a kind of common name and a full name. The formal name is Attorney General South Australia and the City of Adelaide. The common name is the Corner Loop case. Corner Loop. That's because the people who were the plaintiffs were the Corner Loop brothers. Okay, anything else? All right, well, we'll leave it there. Good luck with the exam. I'll just kind of